Mr. Stauffenberg, Ms. Schmidt.
Here.
Mr. Hess. Mr. James. Ms. McBride. Here. Mr. Marcotte.
Present.
Mr. Scholl.
Here.
Mr. Tholen. Mr. Tripp.
Present.
Mr. Washington. Mr. Witten.
Present.
Mr. Cruz. Mr. McCary.
Okay, we have no public comment today. Moving on to the approval of the minutes of September 24. Any additions or corrections? Motion to approve by Mr. Whitten, seconded by Ms. McBride. All in favor say aye.
Aye.
Opposed?
Thank you.
Motion carried. Going on to subdivision number 5, subdivision ordinance. We're going to distribute that. Or you've got it already? Looks like this. This is for your information and perusal. Do you have any questions about it?
Yes, recommended by the RPC. It also has, it reflects the changes recommended by the state's attorney. We're distributing it this meeting, and we'll be discussing it at the next meeting.
Yes.
It's all highlighted. There are 2 sections, pretty major sections, that the state's attorney had us remove. One was for the special service areas, and the other was the homeowners association requirements. It was felt that it's not a good idea to do those at this time, and we'll come back and revisit those.
Highlight sections are added and strike out everything.
Right, that's
All right. Any questions, Mr. Scholl?
Thank you, Mr. Chairman. Will we have a more detailed discussion as to the logic of dropping those, especially the homeowners association at next meeting?
We can, and I've had quite a bit of conversation about that, and I thought it was more important that we get a new ordinance passed, and then we could revisit that over the course of the next few months. Some of the things that we want to do with ASAs are a little more innovative and doesn't have quite the track record that I think there's a feeling of comfort with that. You know, some of the things that we've had to do with homeowners associations, another area in which we've kind of looked at and seen our authorities are a little bit limited. But I think that overall we'll be able to get through that portion of it with them at a later time. So that's kind of why I wanted to see this kind of get moving, and then, you know, to chip away at some of the other issues that we can maybe find some common ground in later.
All right. Anything else? All right. Going on to the Sunset Grove subdivision, the reduction of letter of credit.
Now, the developers are asking that their letter of credit be reduced from $480,372 to $142,584. Our independent engineer did an inspection out there and has determined that that is the correct amount of work that still needs to be done within the subdivision. Currently, they have installed the under drains around the lots. Fire hydrants and gate valves have all been installed. The water mains, the storm sewer. There's some backfilling that was done, and some cleanouts were installed. So that's what they're asking for, is that to be reduced.
Any questions? Is there a motion? Moved by Mr. Marcotte, seconded by Mr. Whitten. Any discussion? All in favor say aye.
Aye.
Opposed? Motion's carried. Going on to number 6, zoning. Special use protest petition you have in your handout. Mr. Mandrala, would you care to speak on number 8? Right there, that microphone. No, right behind you. It should be working.
Is it?
Yes. Yep. Okay. Just tip it up a little bit if you are down for the lady and up for you.
All right, how's that?
Get close.
Pretty close?
Yep.
All right, I'm here today to protest a special use permit against a racetrack and a large crowds, and especially what comes from that is the loud music.
You're going to have to get closer.
Okay, you're close.
I can't hear you.
Tip it up.
Pull it up. What's that?
That's it.
Hold it in your hand, there you go. Just pick it out and hold it in your hand.
Get right in. How's that?
That's good.
Okay, I'm here today to protest the special use permit for the racetrack, large crowds, and loud music. I have a petition here signed by all my neighbors within a mile and a half radius of this horse barn. It was originally the special use permit that I guess was given here back in '01 was for a previous owner, and you have it on file, I have it too, but it says basically that you allowed him to build this barn and have a house built like a year and a half later, and all it's basically said in there was that it was supposed to be used for exercising horses and renting out a dozen to 15 stalls. Then that gentleman lost it to the U.S. Marshal for drugs and some other stuff, and they held it for several years. Then another person of the same type of business that's being run now purchased it 2 years ago and extended it. He is now put in a racetrack, and he's advertising, which in the special use permit said it was not to be used for that. Here's an advertisement I found month and a half ago at 1200 State Street, Chicago Heights. Okay, he has a website. I'll pass all this out. He has a website stating all the dates and times and all the horses that are being raced against each other and everything. Okay, I've had, when this all started a year and a half ago, I had extra traffic coming up and down my lane looking for him. At any given time that they have this functions, there's over 100 vehicles there. Not that that's a big, I guess not a big thing here, just stressing how many people are at these functions, okay? And of course, with a racetrack, if that says anything, it's not really for exercising if they're doing all this advertising. All right, it's got to be gambling going on, okay? So when I put this petition together and started going door to door, I was very surprised at all the people that could hear it further away than I thought anybody could hear it. I'll pass it around. I have, if you pulled up some of the PIN numbers where the people are in coordination to their addresses, okay, and the websites. I made a copy of the flyer too. I mean, I have originals here too, but, and I have some pictures of it too.
How often does this happen? Is it weekly, is it monthly?
Couple weekends a month.
Couple weekends.
Couple weekends a month for the past several years that they've taken it over. And one of your board members who's not here, Jim Vickery, 3 months ago, I was kind of at my wit's end about where to go. I've called county, everything I've been here to county planning and zoning, making complaints. I have copies, you have copies too, but I called Jim over immediately, and he came and he could hear it. You could ask him at any given time. He can vouch for it.
Okay, all we can do is take that information and give it to the department and see what they will do with it.
Okay.
We can't make a decision right now on anything.
All right.
We have to have a recommendation.
Okay.
Take it under advisement, right?
So I'd wait to hear from somebody, or what do we?
Yes. If you'll leave us that, and then we'll deal with it. You'll leave us your information.
Okay.
You'll get it. Is there anything else you'd like to add?
Well, I would hope that it would be researched what they're doing versus the special use permit that was issued, which they're not complying with, and would hope that it would be reviewed and or maybe even pulled, considering that they're running a business when it says clearly in the special use permit, which they didn't obtain, the first owner obtained, that even possibly being pulled. It's not being used for the right purposes, and it's annoying myself and all the other neighbors around, because with all that brings loud music.
Okay, thank you very much.
Thank you.
Mr. Scholl.
Thank you, Mr. Chairman. I wonder if we could have in the record, how far is this from residential dwellings?
How far is the closest residence? Mr. Mandela? How close is the nearest residence to this?
The closest residence?
Yes.
5 acres. The next
I
house.
mean, I don't mean of the residents on that property. I mean the closest resident that signed the petition. How
Right
close?
next door.
Oh, there's one right next door to me that's in between the horse barn and me.
Okay, you are the closest.
No.
No, I'm the second closest.
Okay.
The first closest signed it, plus
Right.
everyone
And
else.
How close is that? Is that within 5?
Oh, their 5 acres touch my 5 acres.
Okay.
But, and the horse barn and my neighbor and myself that we're talking about all live on that, between 8,000 and 9,000 on St. George Road, which is 5,000. And then the other neighbors started on 9,000, feeling out going south and north. They all signed it, they could hear it too.
But you're the next 5 acre parcel east.
The second 5 acre parcel east.
And then there's another person that's between you and them.
That's correct.
Okay.
And then they filter out, like I said, east, west, north, and south.
That is your 5 acres.
5 acres.
Any other questions?
What is the usual procedure if somebody comes in with complaints about something like this, like to the planning department or whatever, what usually?
Well, obviously, we'll take the complaint and we'll go and investigate it. Make a determination if there's any course of action to take as a result of that.
And then you send letters or something, and then what if they don't comply, what
We'll
happens?
refer it to the state's attorney's office
Okay, and then they bring charges against them.
if they deem necessary.
Okay, and that's probably what will happen in this situation.
We'll see.
It'll be investigated at least, right?
Oh, yes.
Yeah, okay. All right, thank you.
Mr. Scholl?
Mike?
Thank you. I just, a question out of curiosity. In something of this nature, or in a situation of a flagrant violation or abuse of a special use permit, when you go through the process, how long does that take? Are we talking about months, years? Just out of curiosity, I have no perception.
Well, typically, when we ever, in my experience, we've taken land use cases to court, judges give preference to the property owner in a lot of situations. The public entity like ourselves has to show that we've done our utmost to get voluntary compliance rather than enforcement. And so typically, a situation, we may give, 3 different, we might give them 3 chances, maybe 45 days and then maybe 30 and then 15. If we don't hear anything after the first time, then we understand that they're not going to take that seriously. And so we gauge what we do based on the amount of amount of cooperation we do receive. So it'll depend on that.
Yes.
One more thing too, everything is documented with planning and zoning as far as the complaints that I did, and they will correlate with the Kankakee County Sheriff's Department. If you check back in the last 2 years under my name, every time that I called and every officer that was dispatched and what they wrote down, they don't give me that information, but I'm sure you can get it.
Okay. Thank you.
Thank you. There you go, Jim.
Okay, going on to planning, a request from the Village of Bourbonnais to enter into an annexation agreement outside their extraterritorial jurisdiction.
About 2 months ago, the county board passed a resolution as a result of legislation that was passed at the state. You may recall at the county board meeting, I mentioned that a case of Chatham versus Sangamon County, in which the city of Chatham developed an annexation agreement with a piece of property that was pretty removed from the existing corporate boundaries of the city of Chatham. Chatham and the county of Sangamon went to court because Chatham went and allowed the property owner to proceed to develop. And as a result of the court cases going through the process even up to the Supreme Court of Illinois. Legislation was passed in the state that said that municipalities, in fact, can impose their regulations, their land use regulations, within their mile and a half. They can be outside the boundaries of the municipality, but within a mile and a half. The other provision of the state statutes stated that the municipalities may do the same outside the mile and a half, except for the case in which the county passes an ordinance or resolution that states that we would maintain our authority outside the mile and a half. That ordinance was passed a couple months ago unanimously. Since that time, I have been approached by the Village of Bourbonnais and Pat Dunn, their attorney, and to talk about a proposed project that's been on the books with the Village of Bourbonnais for some time now, even before we passed that regulation. And so today, the village is here to give us an overview of that project and see and ask for your support for this. So Pat, I'm going to turn it over to you, and then I'll interject as you go along, if that's okay.
Absolutely. Good afternoon. I'm Patrick Dunn. I'm the attorney for the Village of Bourbonnais, and as Michael basically has already informed you about all the aspects of this, the village was negotiating with Right Way previous to your passage of Resolution 2008-08-12-119, and this is beyond our mile and a half boundary, but Right Way is interested in securing access to sewer services, and as you may know, the Village of Bourbonnais requires, at a minimum, a pre-annexation agreement with the village in order to even discuss having access to village sewer services. And in this case, I believe, we have been negotiating that. In the case that Michael had cited to you before, the Village of Chatham case, in that case, the actual distance between the village and where they were annexing or pre-annexing was actually quite significant. I believe there was even a lake in between it, where the village was at and where this actual site was at. In this case, this is significantly different, I think, because the Village of Bourbonnais is expanding its boundaries, or at least plans to, moving towards the west, and that's where this location is at. Of course, we're not near that yet, but we would hope within a 20-year period we would be. We have in the past experienced significant growth towards the north, but our boundaries are now set with both the Village of Bradley and the Village of Mantino, and so we really see our future growth area going towards the west, and that is where this is located at. And the village feels that it's a natural way to enforce what we consider to be our growth restrictions and that, and going in that direction by entering into this pre-annexation agreement. If you have questions specifically about the development, I do have a representative of the developer here, and I would let him answer any of those specific types of questions about the site and what they're planning on doing.
You're not annexing up, or trying to get a pre-annexation agreement up to and through that parcel. You're doing it a spot?
Just the spot, yes. It would. There's a significant distance in between there where there is no pre-annexation agreements. We will not be contiguous to the site for quite a while.
Now, Pat, you do intend to extend sewer and water to the site
Currently,
or to develop?
Currently, sewer is not near the site, but there are plans. The village has made plans within the last couple of years where we've discussed extending the sewer that far. With this agreement, it would require a special service area to be created in this subdivision that would pay for that sewer to be installed when it becomes contiguous.
Will the village approve this on septic and well?
Yes, they would.
They would.
Mm-hmm.
Has the site been bored?
I'm sorry, I couldn't.
Has the site been bored? So about the height of the rock.
I'll let you answer that. This is the representative of the developer, Mr. Dystrom.
Not at this time, but original plans, we had 90 lots. This is a site that only fronts on Route 102. And back when we started this in 2005, there was a plan to extend the sewer out past our property to the women's prison. And we were told numerous times, the funding, it's all approved, we just have to get the funding. Well, we know what's happened to the economics of the state of Illinois, and so we could be waiting another decade for that funding to go out there. So we revised it back to about 45 lots. So we're cutting our density about in half with the hope of proceeding on septic and actually water, because the water out there is all private water. I think it's Illinois American Water Company or whatever the water company is down here. Aqua. And so we have talked to neighbors and to Aqua about extending public water to the site. It's just too far for 45 or 90 lots to extend a sewer down 102, plus there would be a need for a lift station, which who knows how fast anybody would contribute to. But we're willing to develop it at this time, and of course, we feel like we've got 3 years into discussing this with Bourbonnais, which if you don't let us proceed, just 3 years of wasted time dealing with the village, now that you've changed your rules in the interim. So.
Change what rules? What rules you talking about?
Well, back then, under the Chatham case, it was thought that you could do pre-annexation and it was okay outside the 1.5 miles. Now, my understanding of your board is pass some resolution saying only with your permission can you do annexations with properties that's more than 1.5 miles.
Any comments from the committee?
Just a clarification, how far out of the 1.5 miles is it?
You know, I would be guessing.
I think we're more than 1.5 miles, but I think we're less than 2.
Okay, so just, you're 1.75 miles. And they're pre-annexing or annexing
This is a pre-annexation.
for sewer in the future, not for right now,
When it becomes contiguous,
when it becomes contiguous.
when Bourbonnais pushes out to it.
So
Is
why
that
don't
correct?
they wait? They're already gonna have water and they're gonna use septic systems. What is the hurry on the annexation? Just to have the pre-annexation agreement, not to annex? I'm just confused.
Well, yeah,
Want the services.
Karen, one of the things that, under the Chatham philosophy, a municipality can impose its subdivision regulations, its building regulations, its zoning, on a property that's not contiguous. And that was, as being represented, was that negotiations were occurring for the last 3 years. And when the statutes changed to better reflect some safeguards that the county can impose on growth outside the 1.5 miles, we took advantage of that regulation. So, you know, in a pre-annexation agreement, you can make, you know, you can qualify how the standards for development on the property.
So this is something Bourbonnais is requesting, not so much the developer?
Yes.
Okay, gotcha.
Mr. James.
Thank you, Chairman. I have difficulty believing that we should promote anything other than what's already there. If they got 1.5 miles, that's far enough. And the problem is, if this works like a spider web, once you get out that far, you're 1.5 miles. Now, the next thing you know, county's lost control. And I think our regulations are in place for a reason. And I think we made the decision for a very good reason. And I cannot support this. To get within 1.5 miles for bonus, that's another ballgame. But right now, I'm not interested in seeing this approved in any way, shape, or form.
Any other discussion?
Go ahead, I'll speak after.
Now, it brings up the question to me, does that change the 1.5 miles from that piece of property?
No, because it's not technically in their borders. It's not recognized as corporation.
It'd be similar to Ramsey Cove.
It's almost like it would not change the, when Pat approached me on this after he found out that we passed the resolution in August, we had a number of conversations about this. And as I started thinking about how, I would like to, or how I wanted to present this to the PZA committee and the county board, I think there's a couple different things that I think I needed to take in consideration as I started evaluating the policy on this. And, exactly what Stan said is what I said to myself at the beginning. What type of precedent are we setting if we go out there and we arbitrarily say no, or we arbitrarily say yes? And so what is the most obvious thing that we need to go to in looking at our policies for growth and development, and to ensure that we maintain consistency with decision-making processes are obviously our plan. And it was once I started looking at our comprehensive plan, I think my decision-making process became a lot more clear. If you take a look at the location of this, it does fit right in the hamlet area of the Altorf area that Altorf.
So now we know what's going on.
Excuse me. But looking at consistency and development, this was an area that we looked at very closely as a targeted area for rural development versus, let's say, any spider web stand, and that was my concern. But I think from what I looked at from the comprehensive plan perspective, we did identify this area for rural development, for lower density growth and development, clustering, that sort of thing. And that was if we were going to develop it. One of the things that we did not look at as we looked at the comprehensive plan is whether a municipality came into play. And that's something that we should have done and we didn't do in the comp plan. But really, I think to say what is our safeguards from establishing unprecedented growth and saying that we have to approve it every time, is that we look at our comprehensive plan map and determine if it's in areas that we designated for growth in the future. And this one does end up being in one of those locations.
Is there a motion? Do we have to?
I make a motion, we go ahead and approve it.
Okay, is there a second? That it's consistent with the comprehensive plan?
Correct.
That's within your motion? Is there a second? No second.
Call for the question.
Well, did you second it? Then we don't.
They don't have it.
Then we don't have a motion. We don't have a motion.
Next article.
Last for lacks a second, so it does not pass. Going on to the tribe.
Yeah.
Is there another motion?
I make the motion we reject.
You're making a motion to deny.
Yes.
Is there a second for that? Seconded by Mr. James. Any discussion? Ms. Hertzberger.
Besides Stanley, anybody else I'd just like to hear a little argument on this a little bit more.
Start it.
Well, I'm open a little bit, but I just want to hear your reasons why. Elaborate a little bit more on why you don't think we should do it.
After hearing Mike's comment and realizing the less density, bringing it to 45 from 90, and we do have Rhapsody Cove out there.
That's a long ways off.
It's less than a half, that's not a mile.
I think it's
Rhapsody Cove.
This is a mile from this subdivision?
Yeah.
Still.
This is not.
You're still way out of your mile and a half with Rhapsody Cove.
Right.
Rhapsody Cove is a county platted subdivision.
So what are you saying, Rhapsody Cove is a subdivision we should allow Bourbonnais to annex? pre-annexed?
Nope.
No.
No. Oh, well, but so what's the relationship?
I guess I'm talking, if you're against Bourbonnais annexing it, that's your issue. You're not against the development of the site.
Well, I'm really kind of up in the air about it. I mean, I didn't want to second the motion because I can't really say that that's what I would want to do, but these guys are obviously not for it, so I'm just trying to hear their argument.
Mr. James, would you, since you spoke to it, would you be in favor of the development but without the annexation agreement?
I'd have to take a look at it. Have to go through the same process I have to, or anyone else does.
You're against the spot annexation, in other words?
Correct.
Okay. We have a motion, do we have, and a second to deny. Any discussion? All in favor say aye.
Aye.
Opposed?
Aye.
Motion carried. Okay, Tri-Village Development Regulations distribution.
Michelle handed out to all of you this Tri-Village Development Regulation. Michelle handed out the new Tri-Village Development Regulations to all of you. We're just distributing it for your review at this time. We'll discuss it in depth at the next meeting as well. This is a culmination of a couple of years worth of writing and investigating into setting up a different set of regulations for the area around 6,000 road interchange. It makes the requirements a little stricter and emphasis on landscaping and reduction of parking and that sort of thing. So we'll discuss this in depth at the next meeting.
We're talking about going to one meeting a month so that this gives you homework for that one meeting. Okay, going on to other enterprise zone presentation. You want to
Questions?
postpone this to next
Questions?
meeting?
Is it over?
Does anybody have any questions?
Enterprise zone?
Yeah. Let me start from the beginning.
No.
From the beginning, way back when. Back in the early 80s, the state of Illinois enacted legislation that would allow local municipalities to apply to the state and receive an enterprise zone, which is a boundary-specific area within a community for economic development incentives. In 1984, Kankakee County was successful in applying and being awarded an enterprise zone in the urbanized area of Kankakee, Bradley, Bourbonnais, Malone Park, and it's called the Kankakee River Valley Enterprise Zone. And that's the first little handout I have given you. The participating communities, the communities that are involved in the approval or denial or the management of the zone are the city of Kankakee, the Village of Bourbonnais, and Bradley, and Malone Park, and Kankakee County. The reason that these governmental entities are involved is that we have property, we all have property within the zone that we use to target development in one way, shape, or form. The local incentives in the Kankakee River Valley Enterprise Zone are free building permits. There's sales tax abatement on building materials, and if the improvement is in real property, building addition or a new building, there's a property tax abatement, and it's only for manufacturing, industrial, and warehousing uses, okay? And that property tax abatement is 100% the first year, 80% the second year, 60, 40, 20, and 0. So in the 6th year, after the property is on the tax rolls, it's on at 100%. For all the local units of government taxing districts that participate, they will
realize the full portion of their property taxes after the 6th year. Now, now you can see here that there are a number of taxing districts that don't make up as or defined as participating communities. For instance, school districts. For instance, townships. They can participate voluntarily to give up their property tax rate for these developments, and many do. And so, I just wanted to mention that. The other thing is state incentives, and the things that in my new responsibilities with economic development, I'm finding it more and more now extremely important to be able to provide some of the state incentives that are available and being in the enterprise zone. One is there's a natural gas use tax abatement that's very, very important for a lot of our heavy industrial users of natural gas. Another one is for an industry. There's a sales tax abatement on all equipment and machinery that goes into their facilities. And as I mentioned to you, or I may have mentioned to you in different groups, we've done retention visits of about 30 of our top employers in Kankakee County, and already 7 of them coming back to us saying they want to do major improvements and expansions in their facilities. A lot of that has to do with equipment and machinery, and they would get a tax abatement on that machinery itself. So that's an extremely important tool that we use. Couple little, and then we'll go to Karen here. Because the state statutes allow limitations to the square miles that's allowed in a district. Because we have over 4 participating communities, the square miles that are allowed in this district is 15. We currently encompass 11.61 square miles, so we have a remaining 3.39 square miles that we can use. The initial 20 years of this enterprise zone has been in existence for 24 years. The first 20 years, the 20-year expiration was in 2004, and we were able to extend the life of the Kankakee River Valley Enterprise Zone for an additional 10 years, and it is scheduled to expire on July 10th of 2014. That's the Kankakee River Valley Enterprise Zone.
On the natural gas tax abatement and the sales tax abatement of machinery, how long does the natural gas tax abatement run?
It's every year. They have to apply to the Department of Revenue.
They have to apply every year?
They have to apply and get it. I don't know if it goes every year, but initially there's an application. And there's even and it's the use tax. There's another tax within the enterprise zone for natural gas, but it requires well over the number of employees that we'd be required to do. But that's the one that I've been promoting quite a bit lately.
Thank you. Couple questions. First of all, if the property tax abatement only applies to manufacturing, industrial, and warehousing, how did we do the housing part of Hidden Cove with the tax abatement?
There isn't one.
Well,
no property tax.
No property tax. Then why do we have all the tax numbers on there for every for all the housing? He showed that if we were going to take this less in taxes, we'd get this much in taxes, and it would be this much on the housing in this presentation.
I vaguely remember that, but I think he was referring to the sales tax abatement that we would be losing compared to the property tax that we would be gaining at the other end. Because the only thing they're getting is property tax abatement, sales tax abatement on the building materials.
Okay, just for the housing.
Yeah.
Okay.
And for the sports complex.
But not sales tax, or not property tax on the.
No.
No. So, we apply to the state, what are their rules about what properties that we allow into the enterprise zone? What are the rules on that? I mean, what's the criteria?
Okay. That's a good question. I do have some other follow-up here, stuff here, but I'll kind of summarize. When you apply for an extension of an enterprise zone, you can use, there's two options that you can use. That if development is imminent, somebody comes in and shows a development on a piece of paper and says, if I can get enterprise zone, I'm certainly going to do this here. That's an imminent project, and they're committed to the community. We can apply under option 1 of the enterprise zone to extend the enterprise zone using the imminent development criteria. And that is probably done, for me, it's been done 100% of the time. All the way back to, if you can recall, Duke Energy, if you remember that development, when they were here to do the combined cycle energy facility in north of Bourbonnais and south of Manteno. We extended the Manteno enterprise zone because they were in contention of doing that facility there, and that's what one of the requirements they needed. Eminent development is that something would happen within 2 years, and they're committed to doing that. So that's the one option, and like I said, I've used that every time. The other option that I'm pursuing an expansion right now on is similar to, is for the Esselte facility. Surprisingly, the Esselte facility is not in the enterprise zone right now, and I mean, it probably makes sense because that facility's been here since probably the 1930s, so it probably never needed, enterprise zone incentives going forward. Option 2 is not that a project is imminent. It meets some of the criteria for unemployment or for an area that is depressed. And so what we have to do there is we have to take and I think that this is a little, I don't know, I think the jury in my mind is still out on this, but I have to use 2000 census data to come up with the rationale for low income and unemployment to justify extending the enterprise zone to Esselte. And I'm working on getting that changed, but the option B is to use income in the depressed category.
So the eminent development that's coming in does not have to meet the depressed area or the jobs, and all that criteria. It just has to be eminent. Is that what you're trying to say?
Yeah, no, that's what I do. No, that's what I'm trying. That's it.
So they don't have to meet any of that criteria?
No, because Karen and I anticipated that question. When the two enterprise zones were established, remember Sears and Roper, or AleSmith and Roper were going, and at that time, Manteno was, we met the depressed area classification when they established these initially. And so that's where I think that's how that, they use that criteria to establish them, and then you move on. I mean, obviously, this is to help approve things, but yeah.
But Hidden Cove is not in the enterprise zone. So, and we extended it for them, and they were in eminent development, but we did not have to use the criteria of the fact that it was in a depressed area and that it was, we needed to create jobs and all that kind of stuff. We didn't have to use any of that.
We
just
did not,
because they were eminent and contiguous to the enterprise zone, we could just.
well, the whole premise is that you're doing to stimulate economic development in the community. Let me read what the state statutes.
So is there a yes or no answer to that question?
Well, what is the
question
definition?
Is you didn't have to use for that particular development, if it's contiguous to the enterprise zone and you're extending the enterprise zone, it's an eminent development, you know it's coming in, they're gonna do it anyway. You don't have to use that criteria for that particular.
They don't ask for any statistics at that point. I mean, like, when we're using option 2, we have to give them, we have to show that,
So the
that our.
answer is no.
No, I don't think so, no, I don't recall it, no.
Moving on. Mr. Shaw.
Yeah, just out of curiosity, with the Kankakee River Valley Enterprise Zone, with the abatements, is there a figure as to a dollar amount that the county has abated in property tax for a total amount in property tax or sales tax for the enterprise zone? I know we anticipate getting more back than we abate, but just out of curiosity, what has been abated?
No, I haven't computed that. I have gone back and looked at and I don't have the figure here now, but I can go back annually and tell you the investment that has gone on in the enterprise zone and how many jobs have been retained or created as a result of that. We send that semi-annually to the state. No, we can get it for you. We can put something in there for that. But I mean, it's, it's all over the board. Some years it's 500,000, some is 36 million, so.
Mr. James.
Thank you, Mr. Chairman. Mike, out of the 15 square miles you mentioned, there was a figure of mileage left.
Mm-hmm.
What was that?
3.39.
3.39. Okay, now my question is, 3.39, and you're using several options here. One is the abatement, the other one is option 2. My concern is that the 3.9 miles that's left, I would like to see earmarked for exactly what we sold the people on that we brought it in for, which is manufacturing, industrial, and warehousing. And I have to agree with Karen. I don't believe the fact that somebody's coming here regardless is justifiable reason to make a tax break and eat up this economic opportunity we have for real jobs. And I think with only 1.39 miles left, I'd hate to think that we would lose an industry or manufacturing because we sucked up all this enterprise zone in something else other than jobs, quote, quote.
Well, one of the things that we're always doing, Stan, is we're looking at areas that we might be able to take property and remove it from the enterprise zone. We did that in a number of areas back in 2004, and we can probably do it again. To me, I'm looking at ways now to use the enterprise zone with more creative approach, i.e. urban development, urban renewal. Now, there might be a component for residential in a planned area that we want to see urban renewal in, and we're pursuing that a little bit. Does that, it could be a way of fostering, growth and development. So I don't want to close the door on some opportunities like that. So, just a thought, I can see, we're only giving the property tax abatement to those areas that you think are the most important, and that's what the mayors think too. Industry, manufacturing, and warehousing. That's where the biggest local tax incentive, the property tax incentive, that's the only areas that we target. Okay? So, I mean, it is there. Remember, at 3.3 square miles, is that bigger than it's probably larger than the corporate limits of Bradley right now. I'm just guessing, but yeah, I think that's a lot of area. It might be larger than Bradley and Bourbonnais combined.
That was already used up quite a bit.
Well, we put all of Aroma Park is in it, okay? We've included Elks Country Club in it. So those are areas in which, we've done, okay? We've got some areas south of town, all right? So we've tried to keep it balanced, okay?
Any others?
The enterprise zone is, when it was applied for, I guess you applied for it from the state. It's for the whole county, and wherever we want to put it in the whole county.
And that's, Karen, when you talk to me about, how do we, the depressed situation and some of the criteria for that. And you know, we look at it countywide. You know, what's the unemployment rate for Kankakee County versus, you know, other areas? You know, it's a macro versus a micro approach to it.
But there are parts of the county that could really use an enterprise.
Well, and we're battling that right now, and I'll explain to you why. When, you know, these enterprise zones become institutions for the municipalities and, you know, the local units of government that have the ability to use them, you know.
And abuse.
What happened? I don't, there's no abuse to this. And one of the things that happens is that we've had on occasion, we'll have some very preliminary conversations with municipalities or communities that aren't ones that are listed here, and say, hey, we'll extend the enterprise zone out to you. And just be a good neighbor. Where that falls into a little bit of difficulty as we're kind of navigating through this, and I'm navigating the mayors through this, is that any municipality or other county that we would include into this list has a vote now. Okay? And as I mentioned to you guys before, when an expansion is proposed by a municipality, every community has a veto authority. So as you start adding more local units of government, okay, the possibility of giving up some of your rights start to get watered down as well, because they have the ability to veto. So there's a little, I know, that's I've been trying to get around that too.
Well, I'm not saying it should be gotten around. I'm not.
Well, it doesn't make sense. If you're trying to be a good neighbor to somebody that has a project and you have an enterprise zone and they don't, okay? And enterprise zones require an act of legislature. So there's only 97 there's 97 in the state, and there's a map that shows you that. They're not creating them anymore. Okay? So if we can provide assistance so that some community can get a project done, I always thought that was the best thing that we could do. But what ends up happening is, and then that local unit of government gets a vote. So they might be the new kid on the block, but they could stop, one of the, the foundation members from doing something.
Well, it seems to me that all the foundation members vote yes on everybody else's because they don't want to stop anybody else. I mean, so.
I don't know what goes in there.
What's one vote? I mean.
Well, it's veto.
Well, so
they can veto.
One vote makes it no.
Yep. That's what I said. Everybody has a veto vote.
And who makes those rules?
The state. That's a state statute. Now, what we've talked about is making.
But Mike, isn't it only fair? I mean, it's only fair that everybody gets a chance to have help with their community.
What we've done, and we made some inroads where we could put in our intergovernmental agreement that another unit of government would be non-voting, but they'd get to have those. And we've been able to successfully get through that with the state. We could probably get, let's say St. Anne has a big project and we wanted to extend it to St. Anne. They could be part of our enterprise zone, board along with these foundation members, but they don't get a vote. Andy, you didn't have to leave as a result of me saying that.
No. I understand. I wish I could stay and listen to all of it, to be honest with you.
But what we have found is that we can let's say we could allow St. Anne to be a non-voting member, or no, a member, but they have to approve every expansion of the foundation members through an intergovernmental agreement. I don't either, but that's just the way that they work. And I can't answer it, but I'm trying to get it done the simplest way. And that it's just very convoluted. To bring in local units government for a single project is very difficult. And I'm trying to do that because be honest with you, we got two major ones right now that I'm trying to trying to do that. 3, actually.
Going on?
You have a map. Page 3 or page 2 is the Manteno Enterprise Zone. The participating communities here, you can see the difference. Kankakee County and the Village of Manteno are the only two. Again, the same local incentives, except that property tax abatements are allowed for commercial in Manteno. Okay. Because it's less than 4 local units of government, there's only 12 square miles versus the 15, and we only have 1.78 square miles that's being used up at this present time. This enterprise zone will expire on December 10th of 2015. The other pages for you, and I'll just briefly go over them because Karen, then you can have something to refer to later. The executive branch, this is the Illinois Enterprise Zone Act. In the first full paragraph, I would note the last sentence where it starts therefore. It basically gives the basis for why the state encourages the enterprise zones. Down below that, small letter C, you can see how they kind of define distressed area, but I do have some additional information on that on the next page. If you turn over the page, no, it would be the next page after that. If you just turn the page from the one I was referring to, you can see some of the qualifications for enterprise zone expansion. It has to be contiguous. It has certain square miles, like I referenced the 20 and the 15, or the 12 square miles, the 15 square miles. C, it has to be in a depressed area. Now the last 4 pages are from the administrative code. Those are the kind of, well, depressed area is defined here, eligibility criteria. If you looked at depressed area, it goes in a little bit further on the kind of things that they want to see, okay?
It's under F, right?
Yeah. Unemployment, over 120%. The counties is 130 to 160%. Okay. Mm-hmm.
How much is that 120%?
The last year, which was 2007, the state unemployment average was 5.0, and then Kankakee, the city of Kankakee, because I was doing the ESSL, it was 8.8.
So we're over 120.
That was the city of Kankakee. Okay.
I'm sorry.
No.
Well, I'm going to make a controversial statement here, but you know, this is what bugs me about this is, you know, there's poverty, we have to use depressed areas, we have to use unemployment numbers, and we're using countywide numbers that add in all those depressed areas that we really have, and all those impoverished areas that we really have, and all those places with really high unemployment that we have, but none of those places have an enterprise zone. Like Pembroke.
Well, I'm trying to get it out there right now.
Well,
I am.
I know, but it was our last hurrah here, Mike. This was our last effort. You know, we used it all through here and all through there, and all these people, on the foundation, all these cities got to be in there first. And now we're talking about not even allowing places like Pembroke, St. Anne, and other places that are truly depressed areas. We're using all their numbers to bring development to these areas that aren't depressed. But we're not doing anything to get to those areas that truly are depressed, have poverty, and high unemployment.
But I think that if one area of our county prospers, the entire county prospers as well. You can look at it the flip side.
Well,
like
that has not
we
been,
certainly
we've
have
been
to be.
working on this for
We have to
how
do
long
it in
have we
areas,
had these enterprise
and we have to do it in
zones?
areas
How
where I
long
think we need. Well, sort of.
How long have we had?
Well,
And how
1984.
much of it, you know, this is another trickle-down economic situation where this hasn't stretched out to those areas. It hasn't benefited those areas. But those areas, because they're depressed, because they have poverty, because they have high unemployment, have benefited these areas. And this, to me, is an issue. And yeah, it's not right. And, you know, I think that we ought to have a big meeting and do something about it. And it's 20 years have gone by, we got 10 left. We ought to try to do whatever we can for these other areas that we've used those.
I can't apologize for using it. And I set it up the second to the last page, Karen. It is what it is. In the case of a joint application for more than one unit of government, you use the larger geography. The larger geography is the county. I don't know what to do.
You can use what you want to use, but you cannot.
No, I can't. I have to use what they tell me to use.
What I'm saying to you is, you've already, that damage is already done. And if you use okay, fine. You want to use these other area statistics to help these areas. When are we going to reach out? And when are we going to start helping those other areas with things like this? And make a concerted effort to do it. I mean, that's what the last two enterprise zones have really bugged me. Sorry. But that, to me, was those last two have been totally off base. And off, I mean, come on. We're done helping Mantina, we're done helping Bourbonnais, we're done helping Bradley. Let's reach out to some other areas in this county that really could use it.
Okay, moving on.
What's the consensus that we're gonna do then?
You gotta have to start looking on this side of the room, you know?
There's a reason for that.
I think steps have been taken, directing with what Karen said. I agree with her 100% as far as that's how statistics function. But one of the first steps, I believe, is to get transportation out there into the outlying areas, the depressed areas, to enable these people to get to existing jobs. And as far as I'm concerned, that's one thing we do need to really push, and we see developments in that direction. But we need to provide transportation, accessible transportation to those areas to bring them to the jobs.
Recycling program.
I think we'll hold off on that. We'll talk about it later. We went on tour and
Number 10. Thank you, Chairman. I invited Mike Van Mill and his secretary to go to River Valley Recycling. And because they're doing a tremendous job here, we could encourage more recycling because the haulers wouldn't have to haul it as far as they do now. And they can make money off the recycling. We need to work on it.
Any other for the good of the business, for good of the order? Old or new? Motion to adjourn be in order?
Yeah.
Moved by Mr. Tripp, seconded by Mr. Marcotte. All in favor, say aye.